Boerne has its own bookshop. In fact, it's called the Boerne Bookshop. Hi, I'm Dale Adams, inviting you to get lost. Get lost in a good book in our relaxed and casual atmosphere. We have a wide and eclectic selection in the Boerne Bookshop, and we pride ourselves on finding what you're looking for. We do author meet and greets, host writing workshops, and can connect you with a good book club. And your young ones will absolutely love our kids section at the Boerne Bookshop. And while we want you to get lost, we're easy to find, as we're in the heart of Boerne at the back of the Richter Tavern building. We are the Boerne Bookshop.
Boerne Radio 103.9 FM and AM 1500. Coming up a bit later this morning at 11:15, it's Meg Greer with God and Our Dogs. Right now, it's Dale Adams and Ron Cisernos with Ceasefire. And this show is sponsored by the Boerne Bookshop. This is Boerne Radio.
Welcome to Ceasefire, where civics meets civility and engagement meets empowerment. Ceasefire is hosted by former Boerne ISD trustee and owner of the Boerne Bookshop, Dale Adams, and by former Boerne City Council member and local insurance agent, Ron Cisernos. Ready, aim, ceasefire.
Good morning. Welcome to Ceasefire. My name is Dale Adams.
And I'm Ron Cisernos.
And today we've got a show and a guest. Today's show is going to be about the Sixth Amendment of the U.S. Constitution. And first off, I'm going to read it, and I'll introduce our guest. So the Sixth Amendment says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witness against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. And to help us with all of this is Catherine McDaniel.
Well, she is our first assistant criminal district attorney right here in Kendall County.
Yeah, so she has lots of experience with this. Thank you for joining us, Catherine.
Thank you for having me.
I invited you, and when I did, and I told you what we were doing, you said, well, what happened to the first five? And I said, well, we did those already. And you said, well, why didn't you call me on what was it, the fourth?
The fourth, yes.
Yeah, you're an expert on the fourth. You go around the state or the country talking about the Fourth Amendment, and I felt really dumb. I'm like, well, why didn't we call in an expert sooner? But Dale and I, we learn eventually. We're slow learners, but we picked up on it. And it was like, now we've got an expert in the room today to talk about the Sixth Amendment.
When I was reading about this, it really struck me that these are almost all come from their experiences with the Crown in England.
Exactly.
And
yes.
And all the writings point to that. And it's pretty neat that they actually recognized all these issues and decided to do something about it. So
one of the things that I was looking at in preparation for today is kind of what the framers' intent was and what they might be surprised about where we are now in the change of the different experiences. So as you might have thought about, the evolution of the Sixth Amendment in the framers' minds had a large part to do with the way that the king was running the colonies, right? Yeah. In large part that if you were accused of a crime, you were taken back across the ocean to stand trial, not by a jury of your peers, but in Britain, right?
Yeah. So it breaks down actually into almost six separate rights that are related, but they're unique and separate, like the right to a speedy and public trial.
Yes.
The speedy thing is kind of interesting. It sort of has gone away in a lot of ways, hasn't it?
It has and it hasn't, but I'll tell you that it's interesting to me because you do have a right to a speedy trial, but in large part, I think the framers' intent was to slow down the process. They wanted to have a different model than the European model, and it has evolved over time from the ratification in 1789 to where we are now. The speediness is decreased. I know everybody loves lawyers, right? by at the initial times of trial, it was a victim or an accuser against a defendant. There were no lawyers. And so magistrates and judges had a very heavy hand in the way that a trial was conducted. Over time, as lawyers became a thing, and as well as professional law enforcement and professional policing, there became rules of evidence and rules of procedure, documents, and all these kinds of things that sort of prolong it and in some ways ensure a more just outcome, in my view.
Right. one thing that I sort of reminded myself when I was reading this is all for the protection of the defendant.
I
So-
disagree. That is not correct.
No?
It is in large part for the protection of the defendant, but in the greatest good, it is the protection of the public, right? Secret proceedings and the public trial is so that the citizens, the constituents of a community, back in the day, and I still believe very strongly here in Kendall County, people see it as an honor to serve on a jury.
Mhm.
And it is not just the rights of the defendant, it is the rights of the entire citizenry.
Oh, good point.
That's
good
an
point.
interesting perspective.
Yeah, I like that. Okay, another one of the articulated rights here is the right to an impartial jury within the state and district where the crime was committed. And the history of the juries is pretty fascinating. I think maybe that's deeper than we can go today. But the whole trial by fire and ordeals and all these different things, and then the Crown controlling the juries, the grand juries. And I even read about where they had punished a jury if it didn't come to the right conclusion.
So how impartial is that, right?
Yeah, right.
Yeah.
And so I thought that was fascinating, that what the jury process has gone through to get to where it is today. And they recognized all that, and they said it's got to be an impartial jury.
Now, I know that the Sixth Amendment doesn't speak about grand juries, which is a completely different
Yeah.
process. And the way that Texas manifests that has been quite different than the federal or other states. But when you're talking about the impartiality of a jury of your peers, it's very interesting to me to note that, for example, in Texas, women did not serve on juries until 1921,
Oh,
Okay.
wow.
after women
Interesting.
obtained the right to vote in 1920, right? And also, interestingly, Native Americans were not guaranteed the right to vote until 1924.
Okay, so they weren't on juries either. Huh, interesting.
Now, maybe, there is some interesting cases about if you were light-skinned African American or a light-skinned Native American that you might not have been identified as, when there was racial segregation. But really, everything kind of started to get back on board with a truly unbiased jury system in the mid-1900s.
Okay. One thing it talked about was also within the state and district where the crime was committed. I noticed a lot of times one side or the other will try to get a change of venue.
Yes.
And I can understand the concept because you don't want emotion to control what goes on. But at the same time, it does need to be where the crime happened.
Well, because you want people to have a vested interest in
Right.
the outcome, right? And so if you're talking about why shouldn't we try cases out of Bexar County from a part of town that we may not be familiar with, because that's not the way that the law is written. So a change of venue has very specific guidelines and can only be done under very certain circumstances. So, for example, you have to be able to establish that under a very high standard that a jury cannot be seated fairly in the current jurisdiction. Because, and if you think about it, I've participated in trials that did have a change of venue, and it becomes very challenging and burdensome on the entire system.
Right, because everybody's traveling.
Everybody.
Yeah. Okay, the next two are about confronting witnesses and being able to call upon your own witnesses. It used to be that, well, under the king, that the king decided who all the witnesses were. And to be able to actually cross-examine a witness is sort of a new concept, historically speaking. And call your own witness and say, yeah, I wasn't there.
Yes, and again, it becomes part of the sort of more professional standards with attorneys and being able to cross-examine. Now, as a subset of that, you have a right to represent yourself, which can become...
Never a good idea.
There's a saying that I'm not going to put on the podcast, but it becomes quite awkward for some of the victims. If you can think about some more salacious crimes, to have the alleged perpetrator questioning the victim, it can be...
Yeah, that can get
Right.
strange.
Yes, difficult.
Yeah. And the last one that's articulated, it says you have the right to assistance of counsel.
Yes.
And that's pretty prescient because things have gotten so complicated that it's almost impossible to do anything in a legal sense without a lawyer.
And I believe that I read a statistic that upwards of 80% of people who are charged with criminal offenses are able to be represented by a public defender. I don't know if that's accurate, but that was an estimate that I read. The Sixth Amendment obviously was ratified as part of the Bill of Rights in 1791. And then to apply those to the states came through due process of the 14th Amendment. But it wasn't until Gideon versus Wainwright, which was a 1963 United States Supreme Court case, that said that appointed counsel, an indigent defendant is entitled to appointed counsel. So you might have the right to an attorney, but you still got to
can't afford it.
That's right. You still got to figure out how to hire
or no
one.
one. Yeah.
So 1963 kind of changed all that and the system of having public defenders.
So was it common before then for people to not have lawyers?
I think it was common. The other thing that I need to point out is you're entitled to competent representation, which becomes a big point of litigation, right, over the course of time. The sleeping lawyer cases and all those types of things you might have heard about. I know I may look old, but I wasn't practicing before 1963.
I think you're a little younger than me or Dale. So.
But really, as the system has grown and also the complexity of cases, it's become more and more necessary to have counsel appointed instead of someone representing themselves. That's not to say that someone can't still represent themselves because they are entitled to that after a particular proceeding.
And what you do, I assume that you probably run into these issues pretty much all the time.
Yes.
But is it pretty much standard procedures nowadays?
It's very standard, yes.
So there's not really a lot of contention about any of these probably now at this point.
Well, the things that become a point of contention are how much representation you get and in what capacity. So, for example, in some of the larger cases I've tried, one of the things that I've thought a lot about is what the framers might see differently. And so when you talk about the digital evidence, the cell phone data, the drone footage, whatever these things are, that might require not only the appointed lawyer, but for the appointed lawyer to now have an expert to assist in the defense, right? So you're not just being entitled to have counsel represent you, but counsel to have assistance in order to represent you.
Right. Things have gotten a little more complicated in the last couple hundred years.
Yes.
We're going to take a quick break. This is Ceasefire with Dale and Ron. We'll be right back with Catherine McDaniel and talk more about the Sixth Amendment. Boerne has its own bookshop. In fact, it's called the Boerne Bookshop. Hi, I'm Dale Adams, inviting you to get lost. Get lost in a good book in our relaxed and casual atmosphere. We have a wide and eclectic selection in the Boerne Bookshop, and we pride ourselves on finding what you're looking for. We do author meet and greets, host writing workshops, and can connect you with a good book club. And your young ones will absolutely love our kids section at the Boerne Bookshop. And while we want you to get lost, we're easy to find, as we're in the heart of Boerne at the back of the Richter Tavern building. We are the Boerne Bookshop. Welcome back to Ceasefire with Dale and Ron. We've got Catherine McDaniel here. She's helping us with the Sixth Amendment, and I think you've got several cases that you want to discuss with us.
I sure do. So one of the things that we were discussing on the break is sort of the evolution by the framers and how they got to the point of how they drafted and why they drafted the Sixth Amendment. And there's a history of the persecution between the Protestants and the Catholics, the religious persecution that really shaped the Sixth Amendment in large part. And whether you talk about the Tudor religious trials of the 1500s, Bloody Mary's reign subsequent to that, but really it was talking about judicial rights and how the religious persecution in Britain strongly influenced not just the Declaration of Independence, but the Sixth Amendment specifically, and protecting people's rights to a fair trial, which is kind of what I was talking about before, where the Sixth Amendment is just not to guarantee a defendant or an accused person's rights, but really the rights of the entire community to not have a kingdom, to not have a king make the decisions about who's going to trial, why they're going to trial. It is the citizens' right to govern the criminal justice community.
Very interesting. Let me go back a bit. You had talked earlier about Gideon v. Wainwright, and that one of my notes that, when I was looking up notes for the show, the 1963 case, it expanded the right to an attorney to the state and local courts as well.
Correct.
So prior to 1963, that right to an attorney may not have existed in the state of Texas.
It was becoming applicable, right? I mean, you had a right to an attorney, but whether or not you were entitled to appointed counsel, I think, is what became the issue in Gideon versus Wainwright.
Yeah, and what I found fascinating with that is going back to, there's another case, Powell v. Alabama, and this is 1932, and these were 7 black men in Alabama accused of raping 2 white women on a train, one of whom later recanted her allegations, her accusations, and that they had no representation at all in their original trial. This went to the Alabama Supreme Court, still no representation, then got to the Supreme Court, and the Supreme Court says you've got to have representation, but doesn't really say anything about who's paying for that.
Right.
Yeah.
Yes. Yes.
So how does that get resolved? Where does that, the notion that, okay, not only do you get a right to an attorney, but somebody's going to pay for it, how does that come along?
Well, that's a very interesting point, because one of the things that the Supreme Court is sort of notorious for doing is giving kind of a general principle, and then we're all sort of is the minions left to figure out how it actually applies. I can give you some interesting case examples of that. Henry versus Texas is a great example. But overall, it then becomes the state's responsibility and our budget item per county to ensure that indigent defendants. Now, there are grant funds and statewide funds that can provide for that, but where the rubber meets the road is the court has a specific responsibility to ensure that an indigent defendant has representation, competent representation, not an attorney of your choice, right?
Right.
Which becomes an issue of contention sometimes. The other thing I want to mention is that when you look at some of the case titles, you will see state or United States or whatever. So it is a misnomer. When we talk about at the initial turn of the United States, it would have been Dale versus Ron, right? It would be you're the victim and you're the alleged offender. Well, now it's the state of Texas versus Ron. No offense.
That's all right, none taken.
So when did that come about? That's
I can't really tell you without looking it up, but what I can tell you is the evolution is the state has a legitimate interest in public safety. And so the best example that I try to give folks in the community and on jury panels is the reason it says the state is you think about a very standard or very common domestic violence case in which the woman is fearful about coming forward or is maybe dissuaded. And you talked about a woman recanting post-trial. Those things are very commonplace, whether it's an intentional coercion or a regret, and I want to be back with my whole family, whatever the situation might be. So when you think about why it says the state of Texas versus an offender, it's because I am the one as representing the state of Texas, the great state of Texas, I might add, who is charging the offense. Similarly, if you're talking about a murder where the person is deceased, who would be advocating, right?
And that used to be an issue.
Yeah.
Yeah.
I mean, we're here to advocate on the behalf of the entire community because we have an interest in public safety, right?
Interesting.
How, in your position, if you had a defendant in your court and you're prosecuting them and you don't think that their defender is competent, is there any obligation on your part to cease the trial? And I mean, how does that affect you?
The first thing I'd like to point out is Article 2.01 of the Texas Code of Criminal Procedure gives prosecutors a different oath than any other lawyer that practices. I have an oath to seek justice. So to what you're speaking to, if I saw someone who had not reviewed discovery or sleeping lawyer situation or a variety of other things, it becomes very tricky to, number one, stay in your lane, but also, number two, to do your best to ensure that justice is done. You know, as part of that, we work very hard to not overstep. You know, so for example, if I'm trying a case against a less experienced attorney, to not take advantage of that and know that I can maybe get in hearsay or evidence that might not otherwise come in, I have an obligation, a moral and ethical obligation to not overstep.
That's an interesting conflict.
Yes.
You know, and I'm sure that comes up internally anyway a lot just because everybody's different and some people are a little bit better than others, different things.
And also there's some things that you don't know. Trial strategy on the part of the defense lawyer is something that I really can't get in the weeds of. And so you don't know if there's something behind closed doors that prosecutors are not privy to that's like, okay, we're not going to ask this witness any questions because we know if we ask X, then we're going to open this whole bucket of fireworks or something.
Yeah.
So tell me a little bit about your title, First Assistant Criminal District Attorney. Yeah, this is a long title. It's a mouthful. What does that mean? And tell us a little bit about your position.
So in Kendall County, the Kendall County Criminal District Attorney's Office started in 2017. Prior to that, we were a multi-county jurisdiction that was served by the 216th prosecutors who came to this county to handle the felony matters. In 2017, I moved here and helped create the District Attorney's Office with Nicole Bishop. She is who hired me, and she was appointed by the governor. When I came on, the first assistant is typically a very administrative position. So I set up the rules and the procedures and the paperwork and trained the lawyers. And I came to this job with 20 years of experience from the Harris County District Attorney's Office in Houston. So I had supervised and tried probably 150 to 200 cases, many of them murders, many of them capital murders, many of them serial rapes or serial robberies. So that gave us kind of a better overview of kind of the way to handle charging. And, you know, something that I think a lot about is the increase in criminal offenses, right? I think I was listening to a podcast and it was saying that no one even knows how many federal offenses there are because they're in so many different places and so many different books, right?
Yeah.
And it's similar in Texas, right? We have a penal code, but there's also other offenses and all these other codes. So it's become a very large system in order to properly administer justice.
Are you still doing trials yourself now, or are you mostly in the, like, kind of the overseer of?
I'm mostly the overseer. I'll come in and handle them. You know, when I first moved here, we had a murder the third week I was here, and I was very comfortable handling that and prosecuting that as something that has the logistics of, you know, dealing with the Texas Rangers and quite a bit of physical evidence, witness evidence, translation evidence, all this kind of stuff. But now I've tried enough cases. It's good to get the younger lawyers get more experience, and then I try to advise them, specifically like you mentioned on search and seizure in the Fourth Amendment.
Oh, man. Yeah. We'll do the Fourth Amendment show again. We'll have a real expert handle that one for us. Well, you know what? You're here.
That's right.
Tell us about the Fourth Amendment.
Well, so the Fourth Amendment is the right for citizens against unlawful search and seizure, right? So that it has a preference for search warrants. But what it's kind of morphed into over time is, in the manifestation of what I do, is when is a warrant needed and when is a warrant not needed, whether it's for an arrest or for a search. And sort of my specialty has evolved into communications technology. So search warrants for data, for devices, what you need to get. So even something that I teach on nationally is everything from drones to binoculars. What sort of amplification can law enforcement use? And when does it become overly invasive to the private citizen's rights that they need to get a warrant?
Wow.
Would have ever thought about that.
Yeah.
Oh, we missed a great opportunity. We could have done an entire show on that, Dale. What were you thinking?
It's all my fault.
I'm just saying, just Google me. I'm nationally known. I'm just saying. I'm just kidding.
So how did that happen? How did you get from Kendall County to national speaker on the Fourth Amendment?
She was in Houston first, so she got some exposure there.
So in Houston, I was assigned to the Special Crimes Division, and I did large narcotics cartel level cases and gangs. Yeah. That's when a lot of the communications technology was coming up to pass. So I developed a specialty in that. So for example, you may see on some of the Law and Order type shows the ability for law enforcement to locate people based on the use of some of the technology, or even sometimes to prove an alibi, right? Mm-hmm. To say, I was with Dale this whole time. Sometimes we can corroborate that, and sometimes we can refute it. So it's just trying to develop how that technology works, where you get the information and what sort of privacy rights someone has to that data and who has the privacy rights. Does the privacy right belong to the third-party carrier, like AT&T, or does it belong to the individual who's using it?
Yeah, we had a discussion about some of that, but we didn't have the expertise. Well, I'm going to bring up a quick book here because I always bring up a book.
Oh, great.
And I have not cleared this with Catherine, so she may not agree with my choice here. And I haven't read this, but it looks like a fascinating book. It's by Pret Barara, called Doing Justice. It's about a prosecutor's thoughts on crime, punishment, and the rule of law. And he is a federal district attorney in the Southern District of New York from 2009 to 2017. And it just is an interesting memoir / discussion on his experiences and his thoughts on the law as a prosecutor. So we have it at the Boerne Bookshop. If you want to stop by and check it out.
I'm not familiar with that book, but I can say I am familiar with the rule of law.
Yes,
you are.
You are.
And you are a great guest. We'll have you back again we've got 4 more of the Bill of Rights to go now.
Yeah.
So are you entertained by doing any of the other 4 or the last 4?
Well, if you're going to quiz me on which ones they are and which order, I'm probably going to fail that.
No. I wouldn't do that to you. Not on the spot.
Absolutely. I would say that I think that there is a misnomer about how when you read the black letter law, right, in what the Bill of Rights means, how does it actually apply? And so some questions that I get are, so for example, when you talk about the Sixth Amendment, as you mentioned, the general presumption is that it is to guarantee the rights of the accused, and it is, but not only that, right? Yeah. And so it's thinking about stuff in the context of what the framers intended. And the other thing that I'd like to point out is when you're looking at the Sixth Amendment or the Fourth Amendment or any of those things, the key is having an adversarial system in which the judge is not taking over another branch and trying to legislate from the bench, right? So one of the things I was listening to this morning is Justice Gorsuch had a great podcast and was talking about the reason that we have the United States set up the way that it is with the executive branch and the legislative branch, but that the judicial branch is really not intended to draft laws at all.
Yeah.
Right?
Yeah.
And it's when they begin to legislate from the bench that we have confusion about the way that the law should be.
Okay, well, that's going to wrap us up. Thank you for listening to Ceasefire with Dale and Ron and Catherine McDaniel today. And if you missed any of it, you can always go to BoerneRadio.com and listen to it there. Thank you. Boerne has its own bookshop. In fact, it's called the Boerne Bookshop. Hi, I'm Dale Adams, inviting you to get lost. Get lost in a good book in our relaxed and casual atmosphere. We have a wide and eclectic selection in the Boerne Bookshop, and we pride ourselves on finding what you're looking for. We do author meet and greets, host writing workshops, and can connect you with a good book club. And your young ones will absolutely love our kids section at the Boerne Bookshop. And while we want you to get lost, we're easy to find, as we're in the heart of Boerne at the back of the Richter Tavern building. We are the Boerne Bookshop.